Please be seated. We'll hear argument in 2802, Lake Jackson Medical Spa against Gaytan. Justice Slarman cannot be present but expects to participate in the decision of the case.
May it please the court, Ms. Vignair will present argument for the petitioner. The petitioner has reserved 5 minutes for rebuttal.
Good morning. May it please the court, opposing counsel. The Court of Appeals in this case failed to apply the 120-day expert report deadline set forth in the Texas Medical Liability Act. They ignored the fact that the plaintiff judicially admitted that her claim was a healthcare liability claim in the live pleading when the deadline expired. They then let the plaintiff recast her claim after the deadline and allowed her claim to proceed. While the court cited some of the applicable legal authority, it applied a lot of those holdings backwards. It switched the burdens. It never even mentions the presumption that applies when a plaintiff files a lawsuit against a doctor, his affiliate, and his employee for treatment that caused their injury. And the court ignores entirely Diversicare, which of course says, as we know, that a plaintiff cannot recast their claim to right around the act. I stood before this court in 2003 and argued Diversicare versus Rubio for Diversicare. We know that case has been cited umpteen times now for the proposition that a plaintiff cannot recast her claims to get around the act. We also know that case is cited for the proposition that if an expert witness is necessary to establish the plaintiff's claims, a healthcare liability claim has been alleged. But here we are 18 years later, and history has repeated itself, and we have another case before this court where the plaintiff has recast her claims to get out of the act in a case where it's clear that expert testimony is necessary to prove those claims. Just like in Diversicare, this court should reverse and the plaintiff's claim should be dismissed. In Rogers versus Bagley, Justice Huddle said that the act casts a wide net. This court has also held in Loaisiga and Bioderm that the act's applicability is expansive. We also know that the standard of review of whether a claim is a healthcare claim is de novo. So we have two problems in this case. One is procedural, one is substantive. Regarding procedure, the first question is, can a court consider a pleading that's filed after the 120-day expert report deadline? According to the act, the answer is no. If the live pleading on the 120th day judicially admits a healthcare claim, as this one did, doesn't the case have to be dismissed? And again, the answer to that question is yes. If a petition can be considered after the deadline, is a plaintiff allowed to recast their claim to get around the act? And of course, we've known since Diversicare and before, the answer to that question is no. But the Court of Appeals answered all those questions in favor of the plaintiff, and it failed to apply the law. We'll talk about that in a minute. Then as to substance, we have a case, whichever petition you look at, the plaintiff has sued a doctor, his affiliated medical facility, and his employee, alleging that treatments were performed on her that the doctor should have supervised and that she says harmed her. If we follow the rubric of the Texas Medical Liability Act, that claim is a healthcare liability claim, and it should have been dismissed.
Why isn't a claim in an admitted petition a different claim? So it's the claim that has to be dismissed if you miss the deadline. And why wouldn't we think of an admitted petition as stating a different claim?
Well, the issue here, I believe, Your Honor, is that because on the 120th day expert report deadline, which is not movable except for an agreement between the parties, which didn't exist here, she specifically and judicially admitted, I'm suing a doctor, I'm a patient, this is a medical negligence claim, they failed to abide by the proper standards applicable to all of these treatments that this doctor's facility provided to me. And our position is, because she pled herself right into the act, that's the live pleading when the expert report deadline expired. Once the deadline expired, this new petition tried to rewrite around the act, and we say that petition was, one, too late, and two, prohibited by Diversicare. Does that answer your question?
Partially. I'm just, the statute directs the dismissal of the claim.
That's true.
And if the claim is no longer on the table because there's an amended petition, then it doesn't quite line up procedurally?
Well, I think that if she had filed an amended claim maybe before the deadline, we might be having this conversation. But as we say, since that deadline really should be the time at which we're determining whether or not a healthcare liability claim has been alleged, we say that it should be the deadline that applies. What we're concerned about is if we don't apply the deadline that's set forth in the Act, now we've got people once again ignoring that deadline. Now they're filing new petitions. They're trying to recast their claims, which we just know the law does not support. And actually, this case, the Court of Appeals opinion bears all of this out. The court recognizes in its opinion that the plaintiff alleged a negligent medical treatment, a negligent course of medical treatment, that she gave notice under the Act as required. There's specific provisions under the Act for giving notice before you sue a healthcare provider. The court recognized that she alleged she was owed a duty of care as a patient. So then the court recognizes that after we file our motion to dismiss, the plaintiff files this new petition and deletes all references to medical procedures and healthcare liability. Well, that's classic recast. The Court of Appeals should have recognized that at the get-go and just said, this case is dismissed. We know under Diversicare you can't do that. But instead what the court says is, the question is whether the second amended petition asserts a healthcare claim despite the removal of specific reference to the TMLA in the pleadings.
What if they amended their petition to state a claim that was obviously not a healthcare liability claim?
If she had changed her case entirely and pled, I drove up and I slipped and fell in the parking lot, then I agree with you that the face of that petition would not lend itself to all the presumptions required by the Act. Although, as we know, there have been cases where people have slipped and fallen and that's been a healthcare claim. If she had done something like that, the problem is that even with this new petition, setting aside when it was filed, setting aside when that petition was filed, if you look at the second amended petition, she's still alleging the same 9 acts of treatment that she alleges were performed on her that she alleged before. She says that there are breaches of the standards of dermatological care. She says that they improperly used lasers on her. We know this court knows that lasers are considered healthcare liability issues. She alleges the doctor failed to supervise the treatments that were performed upon her, and she alleges the applicable standards of care were not met.
So you don't have to automatically dismiss the whole case because you missed the deadline on the first claim. You do have to look to the amended petition to see whether it still states a healthcare liability claim, and then you dismiss if it does because they missed the deadline on the first claim.
Our position would be that the first claim, Your Honor, is out. All the pleadings everything that she alleged in that first amended petition, the live pleading on the deadline day is over, because it's mandatory under the Act that if no expert report has been filed, when your live pleading on the deadline day alleges health care, you shall be dismissed. That case is out. Now, if limitations hasn't expired and she can bring a claim because she slipped and fell in the parking lot, then that's a whole nother scenario, is what we would suggest. Because again, we're looking at if you apply the Texas Medical Liability Act the way it's written, you're looking at whether or not a healthcare liability claim has been alleged. And a healthcare liability claim is a cause of action against a healthcare provider or a medical doctor for treatment or lack of treatment or other claim departure from accepted standards of medical care or healthcare that proximately causes injury to the claimant. That is precisely what the plaintiff pled in her original petition, her first amended petition, and for that matter, her second amended petition. There is no dispute that Dr. Yarish, one of the defendants, is a medical doctor. There is no dispute that he owns and operates the medical spa. There is no dispute that Ms. Gutzman is his employee. If we run the Texas
But what
Medical...
about treatment? Are these treatments that somebody with a different type of license, like a beautician or a massage therapist or something else, are these treatments that can be provided outside the medical context by someone completely unsupervised by a medical doctor?
Well, the plaintiff alleges in this case that the doctor failed to supervise her, and she says that that's a cause of action. She voluntarily sought out this medical facility. It is a medical facility owned by a doctor to have these particular treatments performed. She talks repeatedly about the dermatological standard of care. We know dermatology is the practice of medicine. Also, there is nothing...
So are you saying that because this is a claim against a doctor, then it automatically concerns treatment?
No, I'm not saying automatically, because again, I know doctors have been sued because a non-patient slipped and fell or something along those lines, but she does allege she was a patient. Her pleadings, to suggest she was not a patient, her pleadings would belie any of that suggestion. Again, she says her medications should have been reviewed, her medical history should have been reviewed. We're not suggesting that simply because he's a doctor, any claim against him is a healthcare liability claim. But if we then apply all the rest of the definitions, you've also got his affiliate and his employee. So all three are healthcare providers covered by the Act. I had to do some of my own research because I was curious. But apparently skin pen is microneedling. Microdermabrasion has been defined by the Garza versus Sines case as a surgical procedure. Phototherapy is lasers. Again, this court has looked at lasers and recognizes that that's a healthcare issue. And then there's this VI peel, which apparently is a moderate depth chemical peel. The 14th court in 2018 had a case where a person alleged that a chemical peel burned them, and there was no dispute that was a healthcare liability claim. We have cited other cases in our briefing that show the court that issues related to these dermatological procedures are either undisputedly health care, or the courts have held that they are health care by running through the Medical Act rubric, which is, are these people health care providers? Has treatment been alleged? We also have a couple other things to talk about. The presumption. A presumption attaches when the plaintiff sues a healthcare provider alleging treatment injured them. That is what Ms. Gaytan alleged. So the presumption applied, which required her to rebut the presumption, which she did not do. The Court of Appeals kept switching the burden and putting it on us and suggesting that it was our responsibility to show we're not healthcare providers, even though we're defined the same under the Act, that this was not a healthcare liability claim. Those were not our burdens. Her petition pled her squarely into the Act and into that presumption.
Before you run out of time, can I just take you back? I just want to make sure I understand where you are on the deadline issue.
Yes.
Plaintiff files a healthcare liability claim.
Yes.
120 days runs. You file a motion to dismiss because there's no expert report. What if before the 120 days runs, she files a supplemental, not an amended, but a supplemental petition, slip and fall? Same case though, just
Sure.
Two separate claims now. 120 days runs, you file a motion to dismiss the healthcare liability claim, but you can't file a motion to dismiss the slip and fall, right?
Depending on the circumstances, true.
The hypo you were giving
in the
out
parking lot, sure.
and all that. Okay.
Yes.
But then what if instead she files the healthcare liability claim, 120 days runs, you file a motion to dismiss, and we know that claim shall be dismissed. You file a motion to dismiss, but before the hearing, she files a supplemental petition asserting the slip and fall. Now we get to the hearing. Are you saying the judge must dismiss the whole case, both of them? Or should the judge only dismiss the healthcare liability claim and then the later supplemented slip and fall can continue?
I would say my immediate reaction to that is that it's the healthcare liability claim that is governed by the Texas Medical Liability Act. So if it's a healthcare liability claim and the expert report was not served to support it, that shall be dismissed. Right. If there is some other part of the case, and we have to remember, as long as we're not claim splitting or any of those sorts of things, because we know we can't do that, if we really legitimately have something entirely separate and apart, then I think I would have to say that it sounds like the Medical Liability Act may not apply to that claim.
Right, and so in that hypothetical, the trial court should not dismiss the entire case. It should dismiss the healthcare liability claim, but allow the slip and fall to proceed, even though
the slip and fall was only pleaded after you filed your motion to dismiss.
Well, because
You
the
agree
only
with
other
that?
deadline I could think of that would apply to the slip and fall would be a statute of limitations then.
Right, assume
Yeah.
all this happens before.
No, I think if I'm being intellectually honest with the court, I think that would be the way that it would apply. Now, if I drive home later and something hits
Right.
me, I'd love to
Well,
file
but if we
something
change the
supplemental.
hypo so it's no longer a supplemental petition, instead it's an amended petition that gets rid of the healthcare liability claim and replaces it with the slip and fall in the parking lot, seems to me the result should be the same. The trial court should not dismiss it because of the missed deadline, because the deadline doesn't apply to the slip and fall.
I think I would agree with that. The result is the same because now the healthcare liability claim is gone. And we know you're not allowed to just dismiss to make it go away.
And so
you can
why
get
in
around
this
it.
case is it a question of the deadline when really it's just a question of whether the amended claim is a healthcare liability claim? And I get all your arguments on that, but it doesn't seem like it's the deadline that you should be hanging your hat on here.
Well, the reason that we are focused on the deadline in this case is because we say that on that deadline, the plaintiff's petition, as we've said several times, did judicially admit a healthcare liability claim. I mean, she was dead to rights under the TMLA when that report deadline expired, and she was on notice. We filed 2 different pleas in abatement telling her to file her expert report, and she didn't do it. Instead, she added the medical doctor, and to my mind, made it worse for herself. We say that all of these claims, as pled by the plaintiff, are healthcare liability claims. That we don't have a slip and fall in the parking lot. Right. These claims must be dismissed under the Medical Liability Act because the plaintiff did not file an expert report to support them. The presumption was in our favor. An expert testimony is required to support every claim that she has made. We believe that the Court of Appeals procedurally got this wrong and substantively got this wrong, and we're asking for a remand because we've pled attorney's fees as we're entitled to under the Act, and we've kept that claim alive throughout the proceeding.
Any other questions? Thank you, Ms. Vickner.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Armstrong will present argument for the respondent.
Good morning. May it please the court. Your Honors, over the course of many years and in several opinions, this court has been very clear in giving instructions to the lower courts about certain things that they should do to evaluate whether a healthcare liability claim exists. We believe that first the trial judge and then the 14th Court of Appeals followed this court's instructions to the letter and reached the right result. We say that because we know that this court has instructed the courts to, whenever you are presented with what on its surface may be a healthcare liability claim, to go beyond the pleadings and evaluating that and determine what the nature of the claim is and whether the nature of that claim is in fact a healthcare liability claim. You have instructed the lower courts to look at certain things. One of the things that has been crystal clear over the years is there must be a doctor-patient relationship. The trial court and the 14th Court of Appeals looked at the facts of this case and decided there was never a doctor-patient relationship. And that's really what the 14th Court of Appeals' decision turned on. I mean, that's evident throughout their opinion. And they didn't reach the issue. The second issue that you all have instructed courts to look at is whether there was actually medical care performed or some type of administrative function that is directly related to health care. The 14th never reached that issue in its opinion, but it could have. And if it had reached that decision, the result would still be the same. Because on the record before both courts and before this court, there is not a doctor-patient relationship, and there is no medical care that was performed. And if we start with the doctor,
treatment?
There was, but Your Honor, I think part of the problem that led to some of the drafting decisions in all of the petitions, and part of the confusion here even at the argument today, is treatment and the way it's used in this specific context. What Ms. Gaytan did was she walked into a medical spa She met with an esthetician. The esthetician gave her an over-the-counter cream that she said was a treatment, the terminology treatment, and then she did some photo light therapy on her blemishes. There was no surgical procedure. There weren't the type of lasers involved in this situation as what has been involved in, say, the Bioderm case or some of the other what's called invasive lasers procedures that are involved in other cases where this court has found that there was a healthcare liability claim. And so what the court looked at, what both courts looked at to determine that there was no doctor-patient relationship was the fact that Ms. Gaytan did not fill out any informed consent forms when she met with the esthetician. She didn't do any new patient sign-up sheets for Dr. Yarish. Dr. Yarish, importantly, didn't examine her. He never did a physical examination of her. He didn't diagnose her. He didn't give her a prognosis.
But is the crux of your allegation in the case that that was a failure, a departure from the standard of care, to fail to obtain a medical history, to fail to have doctor supervision over this employee? And how do you respond to their argument that your complaint is lack of medical supervision, so that has to mean it's a cause of action under the Healthcare Liability Act? How do you address that?
Well, Your Honor, again, we go back to the instruction of this court time and again to look past the pleadings to see what the actual nature of the claim is. Now, granted, we pled a dermatological standard of care or medical standard of care that wasn't complied with, and then we tried to amend to get rid of some of the confusion about what the actual claim is. Our claim, the crux of our claim, and I think this is what the 14th saw, is the fact that he owns the property. There are things that are being engaged in on his property that were unsupervised, but they're not medical care. And as the owner of a facility where you have employees doing these non-medical things, you have certain just ordinary negligent standard duties to supervise your employees when they're doing that. And so I think what we see is it's akin to what this court has said before, and I'll quote it in one of the in the Loisaga case, where it says, "We fail to see how the legislature could have intended the requirement of an expert report to apply under circumstances where the conduct to which the plaintiff complains is wholly and conclusively inconsistent and thus separable from the rendition of," and they quote it, "medical care, health care, or safety or professional administrative services directly related to health care." And so by this court's instructions, there are instances where a physician can be held liable for activities that aren't health care related. And one of the things that is telling in reaching I don't know if the 14th considers this, but I submit that you all should consider this. In determining whether or not these treatments that my client underwent were health care, you can look at the Texas Department of Licensing and Regulations website. They have a frequently asked questions web page, because this area of medical spas is so confusing as to what's medical treatment and what's not. And so they have a frequently asked questions section, right? And we didn't see this at the time that we were drafting, or we wouldn't have made some of the petition drafting errors that we did. But it says clearly, estheticians are not medical practitioners. And the services that they provide are not the practice of medicine in Texas, right? And so it does say that there are instances where an esthetician who is licensed to perform laser surgery can be supervised by a physician, and they could perform that surgery. But if they're not licensed to use these very invasive lasers that were not at issue in this case, then it's not the practice of medicine. There also is a Texas Administrative Code, 193.172. And that states that in instances where a non-physician is performing services that are medical, whether they're non-surgical medical procedures or surgical medical procedures, that there are certain things that the law of the state of Texas requires that physician to do, which is all the things that weren't done in this instance. Do a physical examination of the patient, have informed consent forms, have medical histories conducted of the patient, generate written medical records, things of that nature. And so I think it would be a stretch to say that what my client underwent was medical care.
If it's not medical care, though, and if we agree with you on that, the statute also applies to health care and to treatment or lack of treatment, and each of those is separated by or. So don't we have to give those other terms, like treatment, a different meaning from medical care?
I think what the legislature, if you read that term in the context of this act, I think what the legislature intended to say was medical treatment, right, as opposed to skin treatments. And by way of example, the skin pins that my client had put on her face and on her back, I could go on Amazon.com right now and get that for like $200, right? Or I can buy a set of those things for a couple of $100. Those are not medical instruments that a medical professional would have to have. The lasers to contrast that, the lasers involved in cases where this court has said there was medical treatment involved, it involved treatments that were laser treatments for heavily regulated lasers that you only can obtain if you are a medical professional. I mean, does that make sense, Your Honor? Okay, and so I think when we look at everything in context and we look at the TMLA and we read the term treatment in context, I think the legislator intended it to apply only to medical treatment.
So I understand your argument, this is not a healthcare liability claim, but it seems that it's at least close to the line, it's at least debatable whether it is, and that being the case, why not just get an expert report to get that out of the way and take this argument off the table for them?
Well, because it was not required of us at the time. When we began to look very deeply at what these treatments were, our understanding shifted that these were not medical treatments, right? And so what we would then have done is complied with a requirement of the statute, expended money to get an expert in a situation where that wasn't necessary. And this court has always instructed courts that if there is not a healthcare liability claim, you don't have to get an expert report. I mean, this is where these fights are usually had, at the point where do we need an expert report?
Would you need an expert at trial?
I would submit that we do not, right? So the two products that were used in combination that we are complaining about are both over-the-counter products. Estheticians are trained on how to use these over-the-counter products. I would venture, and I'm not sure because we've never gotten to this point, but I would venture to guess that if we looked at product warnings and labels for these two products, they would probably say, don't use these two things in combination. And an esthetician would be able to tell us, hey, when I was being trained, I learned not to use these two things in combination.
Isn't that an expert qualified by experience?
But I think and I understand what the point you're raising, Your Honor, is that you would need an expert. The cases that have said, if you need an expert, it's a healthcare liability claim. But I would ask the court, then what does that say for instances where medical treatment is involved? Does that preclude you from bringing an expert that's another esthetician or another med spa business owner that says, yeah, we never allow our people to use those two things in context? They would be an expert, but they're not a medical expert, right? And so I think the court's prior cases that have said, if you need an expert, it's a healthcare liability case. Again, I think that is in the context of, if you need a medical expert, it is a HCLC. If I may just wanted to, if there are no other questions on that issue, I'd like to spend just a couple of minutes on the deadline issue. First of all, we don't think, our argument, and we would submit to the court, that issue is not before the court properly. It was not an issue that was raised in the trial court. It was not an issue that was assigned as an assignment of error in the 14th Court of Appeals, right? And so we know by Texas Rules of Appellate Procedure, I think 52, says that you have to present these types of issues to the appeals court before they are properly before the Supreme Court. And so we would argue that specific deadline issue is not properly before the court and it shouldn't be considered. But even if the court were to consider it, I think it tracks back to what has this court tasked the lower courts to do. And I don't think that we'd ever find an opinion of this court that has said, you have to analyze, you have to beat the 120-day statute to determine whether the true nature of this case is a healthcare liability claim or not. I couldn't find any case where this court has said that is a requirement. So I think that even at the point of after the filing of a dismissal motion, we have the right under the law to do exactly what we did. Ask the court to determine whether we even needed to submit an expert report. And I think that's what these courts have done.
You agree, though, that if your amended petition states a healthcare liability claim, it has to be dismissed because it sort of relates back to the deadlines that applied to the original case, the 120 days?
I think if the nature of the claim is a healthcare liability claim, anywhere in the process, it would be dismissed at the 120-day stage.
So you're not saying you get another 120 days or that there's some other deadline? Or
No, Your Honor, absolutely not. I think the courts have been pretty clear about that 120-day deadline is a hard deadline in instances where you really are dealing with a healthcare liability claim. It can't be extended. It can't be amended around. And I submit to the court that is not what we were attempting to do. In our amended, to show you the confusion when drafting, in our amended, even our amended, second amended petition, we referenced dermatological care standards because we thought the skin is dermis, right? That's not what it is. We found out later it is cosmetological standards of care, which are non-medical by virtue of Texas law. The Texas Department of Licensing and Regulation has said that. But I think that is the reason there is a frequently asked question on that webpage, because these issues are so close that it's hard to determine where the medical ends.
So to be clear, you're not saying that after they filed a motion to dismiss, you amended to state a completely different claim like the slip and fall we were talking about. You're saying you amended to clarify what was the true nature of your claim all along.
Correct, Your Honor.
So, and that's why, to answer, to refer back to Justice Blacklock's question, if we agreed with the petitioner that the true nature of your claim all along was a healthcare liability claim, then the original 120-day deadline would apply.
That's correct, Your Honor.
The amendment wouldn't give you a new one.
That's correct. And that has never been our argument, right? Our argument all along has been that this was not a healthcare liability claim. And so I think, even in terms of how the 14th Court of Appeals phrased its opinion, they looked at it as whether or not my client had sufficiently rebutted the rebuttable assumption that when you sue a medical provider, it is a healthcare liability claim, right? And they've analyzed it solely on the issue of whether or not the absence of a patient-doctor-physician relationship rebut that assumption. And in their opinion, it did. I think that was the correct result. And you know, when I started, I said they didn't reach the medical issue, but I think they could have and reached the same result for the reasons that we've all talked about right now. I don't want to run past time, but I thank you all for examining this issue closely. I think it is a issue that needs to be examined correctly and issue that needs to be discussed, specifically in the context of medical spas, because it's not a one-on-one relationship between a medical spa equals their practice in medicine. There are other things that happen there that are not healthcare related. And in particular, I think in this instance, if you were to overrule the 14th Court of Appeals, I think you would actually be materially altering the instructions that you have given to courts on this issue in your prior opinions. Because I think this really is a fact-based analysis that followed down the line your prior instructions on how to handle these types of claims, and the courts did exactly what you told them to do.
Any other questions? Thank you, Mr. Armstrong. Ms. Vickner, I believe you have 5 minutes.
Thank you, Your Honor. In listening to opposing counsel's argument, I kept getting the sense that this sounded like just classic Diversicare recast. It also struck me that much of what he discussed with the court this morning is nowhere in the record. He's the plaintiff. He had to rebut the presumption. He presented nothing in this record that had anything to do with what Ms. Gutzman was and wasn't allowed to do, what were these procedures that he said were performed on his client. Because healthcare providers were sued, and they were sued for allegedly providing negligent treatment to this patient, then it was up to him to show this court that those treatments were not medical treatments or healthcare treatments, to Justice Busby's point. The Texas Medical Liability Act, in all its incantations, has been around for a long time. This court has written on it so many times. The courts of appeals have written on it so many times. Claimants are sort of at their peril when they're filing their petitions in courts, alleging claims against doctors and their affiliates and their employees, alleging treatments were performed on them that injured them. The presumption applies. This court has noted in multiple of its decisions, the expert report requirement is triggered when a plaintiff names a person or entity as a defendant and seeks to obtain relief from them based on facts that possibly implicate the TMLA. That's Lois Sega. This court.
Given the various concessions that have been made this morning, how about if we just assume good faith on everybody's part that we're trying to get to the true nature of these claims and look at the live petition to decide if this is a healthcare liability claim or not, rather than getting into whether it's recasting or not.
And Your Honor, to your point, then let's take that petition, let's juxtapose it with the Texas Medical Liability Act, and then let's run through the definitions and run through the rubric. So we know Dr. Yarish is a physician, check. His facility is affiliated, check. And Gutzman is the employee, check. So now we've all got healthcare providers. She is clearly alleging treatment, and on top of that, alleging abrasive dermatological treatment in her second amended petition.
And what do you say in response to counsel's point that the TDLR doesn't consider that medical treatment and it needs to be medical treatment?
If she alleges, not only in her petition, but she says in her affidavit that they performed microneedling on her, phototherapy, microdermabrasion, which again, as I've stated, is supposed to be surgical. My position would be the label that's been placed on her does not necessarily capture what exactly she was and what exactly her job entailed. If it was purely cosmetological, then why did a doctor need to supervise? Plaintiff has alleged that the doctor failed to supervise these treatments as he should have, and she was injured as a result. We say that, again, cosmetology does not appear to truly be the issue in this case based upon plaintiff's own affidavit and what she says was performed upon her. And as we've talked about, an expert is going to be required to determine whether Dr. Yarish properly supervised his patient, his employee, when she performed these various treatments on this patient. A layperson in their common knowledge does not know what the dermatological standards are, does not know what IV peel is, does not know what microdermabrasion is, VI skin pen, and all these other phototherapies and all these things. A medical expert is going to be required, or a healthcare expert. There are two different provisions in the TMLA. One is qualifications for a medical expert, one is qualifications for a healthcare expert, so we know they're two different things. And we say that if you look at this petition, you juxtapose it with the act, we know a presumption is supposed to apply. This court has stated on multiple times, we look first to the pleadings. You said that in Loaisiga. Justice Bland said that in the Coming Attractions case, that the pleadings bore out the fact that her claims were healthcare liability claims. And as this court has said, filing an expert report is a low threshold for a plaintiff who brings a claim against a healthcare provider alleging that treatment caused their injury. So to the point that was made earlier about why not just go ahead and get an expert report on file, this court has considered that in other contexts as well. It is a low threshold for the plaintiff. If it's borne out later, it's not a healthcare liability claim, so be it, but they've escaped the deadline that's mandatory under the statute.
Do you agree that some estheticians do not provide services that are not healthcare and are not healthcare providers?
Do some estheticians provide, yes.
Provide services that are not healthcare?
I think I have to. I guess estheticians can do a number of different things, many of which are not medical care or health care. I suppose if Ms. Gaytan was alleging maybe that she had gone in and had her eyebrows waxed or something, maybe that would be different, although I don't know. It would depend on what the injury was that was complained about. But again, it was a presumption applied to the pleading that the plaintiff had to rebut, and she did not provide this court with anything in this record to suggest that what she was alleging was performed on her was not health care. So for all of these reasons, we would submit to the court that the 14th Court of Appeals opinion should be reversed. We believe that they actually applied standards backwards, applied some of the guiding rules and principles backwards, and we actually think that they have rewritten medical liability litigation as we know it. And so we're asking for a remand so that we can have these claims dismissed and have our attorney's fees and costs awarded to us. And I will give a little, I'm over. My apologies. Are there any other questions of the court?
Any other questions? Thank you, Ms. Vickner.
Thank you very much. Have a good day.
The case is submitted. That concludes the arguments in the cases set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.